So I have a client who came to me in 2021. They came to me with a mutual separation agreement that had been signed, and they had been given close to 500,000. This is someone who came in post the event of signing that mutual separation agreement and being given a token of 500,000. But then when they were reviewing that agreement, they wondered to themselves, did I really agree to be separated from my employer? Was this mutual, or was I fired, but it was just clothed as mutual separation agreement? Now, this client, when they came to my office and I looked at the terms therein, I actually realized the employer had wanted to let this person go. And then I interrogated the facts. Turns out, because he was a general manager, when a new CEO was brought in, the new CEO wanted new blood and wanted his own people who believe in his own set of ideas and wanted a very easy way to let this person go with the least amount of drama and without having to pay them well. Because this person was also anxious, this general manager was actually anxious about being let go and the market knowing that he was fired. He thought that the right thing to do is to sign this agreement. It is only now when we looked at number one, the facts around the separation, were they mutual? You remember I said it's called a mutual separation agreement, meaning that we, you and I, as employer-employee, have mutually agreed, or we have agreed, and we have the meeting of the minds, that the best way for us to continue with the future is to separate. So when we looked at this mutual separation agreement, if an employer wants you out, is it really mutual? Am I being fired? And then it's being clothed mutual separation agreement. And we went to court to deal with this matter. And one of the defenses that the employer had was, but they signed the agreement. We gave them this amount. Our argument in court was, it wasn't mutual. They were trying to let this person go. They knew that this person had huge financial obligations. They knew that this person wanted to protect their reputation as general manager within the organization. How the process was done was extremely rushed, and perhaps to just give you a bit of history, he was called in the morning. He was told, we want to let you go. You have a choice. You can either resign or you sign the mutual separation agreement. It's up to you. By end of day, we want an answer. So he was just given 24 hours. Is that mutual? That's not a mutual separation agreement. And when we went and argued our case in court, the court was completely persuaded that there is no way an employee who's been given 24 hours to either resign or sign an agreement is a willing participant in such an agreement. And that just because you have decided to come with clever ways to let an employee go, without necessarily following the due process, is there a valid reason? You remember we talked about there must be a valid reason and there must be due process. Was there a valid reason to let this person go? None was stated in the mutual separation agreement other than the fact that the new CEO did not want to see the general manager. Was there a due process? Surely, if you're told in the morning that we need an answer by COB, do you even have enough time to interrogate? Due process was not followed. And this person, who was at the time was earning around 250,000 per month, was compensated 250,000 times 12, because that is the maximum that the court can award. It can only award you 12 months of your salary. And that goes to show that you can actually take your power back as an employee, even when an employer is trying to be coy and cunning. Thank you so much. Please engage with us if you have had a similar situation. My name is Stella Wangoi Muragori, Managing Partner at MMW Advocates LLP, and that's a Kenyan lawyer's perspective.